Hello everyone, today I'll be sharing another legal story with you. So what happened on 9 September 2025 is that the Supreme Court was dealing with the case of George Kutti Chako versus MN Saji. Okay, this case of George Kutti, it arose after the decision of the Kerala High Court. Okay, so the Kerala High Court in its decision, they deducted the loan amount from 30.8 lakh rupees to 22 lakh just because 8.8 lakhs were paid in a cash and they were not disbursed through a banking channel, right? And they lack a documentary proof because it was not disbursed via banking channel, right? So this was the decision of the Kerala High Court where they deducted the amount of 30.8 lakhs to 22 lakhs just because 22 lakhs were paid through a banking channel and they have a documentary proof, and the 8.8 lakh rupees were paid via cash and they do not have a documentary proof, right? On this, the appellant, he filed an appeal before the Supreme Court and he contended before the Supreme Court that the High Court has failed to acknowledge the promissory note of the respondent where he admitted receiving 30.8 lakhs from the appellant. So the appellant submitted before the court that High Court has failed to acknowledge the fact of promissory note where the respondent has admitted of receiving 30.8 lakh rupees from the appellant, right? On hearing this, the Supreme Court set aside the decision of the High Court, stating that once the genuineness of a promissory note is accepted and the presumption regarding the whole payment is raised unless contrary proved. So the Supreme Court said that the promissory note clearly mentions the fact regarding the admission regarding that 30.8 lakh rupees has been admitted by the respondent from the appellant, and once the genuineness of that promissory note is once proved or it is accepted, the presumption regarding the whole payment is raised unless it is contrary proved by the respondent. And the Supreme Court also said that the High Court has erred in bifurcating the loan into proven and not proven, okay, components, as cash components in commercial transaction cannot be disregarded just because it lacks receipt or bank record. So the court clearly said that the High Court has erred in bifurcating the components of loan into proven and not proven. And secondly, in commercial transaction, just because the payment is made via cash, we cannot disregard that payment, and therefore any absence of documentary proof would not negate the cash transaction. Just because the payment is made through cash, we will not negate such kind of transaction and we will also include such transaction. Okay, so this is what was happened in this case. Thank you so much.